morning, everyone. It's an honor to be here at the Mid-American Truck Show. Today, we're going to have a little session on, we're going to give an FMCSA update, program update. We'll welcome some questions after the presenters here talk about their subjects. Basically, I'm going to introduce Robin Hutcheson, our acting administrator. She'll give you some overall agency priorities. And then I'm going to have our two guest speakers here, Tom Libatori, who's going to talk a little bit about our entry-level driver training program, and then Brian Price will talk about our drug and alcohol clearinghouse. So just gear it up. You can ask those guys questions, and they'll have the answers for you, I hope. If not, we'll get back to you, seriously. This is your show. We want you to be informed, leave informed. So welcome. But first, I want to introduce Robin Hutcheson. Robin became our acting administrator in January of this year. Prior to being acting administrator, she worked directly for the Secretary of Transportation as the Deputy Assistant Secretary for Safety Policy. She was very instrumental, and quite frankly, Robin was the architect for the development of the bipartisan infrastructure law. She's here to listen to you guys. She's here to learn. She's here to address concerns. And she's going to implement our policies that are required in the bipartisan infrastructure law. Prior to joining the Department of Transportation, she was the Director of Public Works in Minneapolis. And before that, she was the Transportation Director in Salt Lake City. Robin brings a lot of experience to the agency. She brings some common sense approach, and she is a doer, and she'll get things done, and she wants to be listening to you guys. So at this time, I'd like to introduce Acting Administrator Robin Hutcheson.
Good morning, everyone. Oh, I love that. Thanks for the response. It makes me feel very at home. Jack, thanks so much for the great introduction. He's usually a little over-complimentary on my accomplishments, and I appreciate that. Jack does a great job for us as the executive director of our organization, so thanks, Jack, for everything that you do. I am more than pleased to be here with you today, and I was here most of the day yesterday. And while we are here to share information out with you in this session, I want you to know that every minute that we've been here up to this point has been about not us sharing out, but us listening in. We've met with numerous folks. We're hearing from you directly, the drivers. And I want to say that you are an essential workforce. We know that. I'm here on behalf of Secretary Buttigieg, who speaks often of truckers and the trucking industry and our responsibility to lift your work up. So for everything that you do for this country, thank you. So you're about to hear from some of my colleagues, and they're going to speak to you about a few specific things that we think are going to provide good, detailed information for you. And I'm going to start us off with just a few big picture things that we have our eye on and that we're working on and that I think you care about. The first thing I'm going to just touch on very quickly is something that we launched from the U.S. Department of Transportation in January. It was an effort from the Secretary. I worked really hard on it. Jack worked really hard on it. And even Larry Miner at FMCSA, he worked really hard on it. It's called the National Roadway Safety Strategy. And if it's one thing I know we share in common, always, all the time, it's safety. Safety on our roadways. This strategy recognizes that 0 is the right number of deaths on our roadways. And we shouldn't accept anything less. To do that, we got to take some action, and we need to rely on others to also take action, all of our partners. And we hope to achieve this goal, but we know it will take some time. The strategy is a statement of our policy and our beliefs. We know we share the desire that everyone who we work with and for, and who works for us, and who works hard for the American people deserves to go home safe every day or at the end of every shift, safe to their families and their loved ones. Second thing I'm going to talk about is this truck action plans. This is a Biden-Harris administration initiative. Our role in this has been pretty specific in that in the last several months, we've been working really hard to remove the barriers for individuals to obtain their CDL. So we've made some headway. We know that we have capacity issues in the driving community. We need to recruit, retain, and produce more drivers that want to come into the profession and stay in the profession. The CDL is really the first step. So we've been working really hard on that. The third thing I'll mention is that some of the issues that we know, that we hear from you, will take some time to study to get to the bottom of the issues. And we have a few long-term studies, and as Jack mentioned, the bipartisan infrastructure law, sure, it increases funds, it's really gonna help, but it also directs us, the Federal Motor Carrier Safety Administration, to do a few studies. Those are gonna take a little time, but we hope that when we come back here to MATS in the coming years, we can report back to you on a few key studies, the results of a study too. Look at detention time and how that affects people's pay, and to look at overall driver compensation. We know that this is an industry that is so vital. We know that you are essential workers, and we know that we need to study why, when you feel like you aren't being compensated the way you should be, or detention time is a barrier for you, we should understand exactly why. I am not your detailed person, and I know that there's some information that you are here to hear about from FMCSA. I'll close out by just saying that if you've read my bio, and Jack just said it, I'm about 60 days into this position. And as I was speaking to someone earlier this morning, I was saying that I don't want to do small things in the seat that I sit in when I have the power to make change. I want to do big, impactful things, and that to me is this industry and this job. So I only do that with you, hearing from you, and being present in your engagements and your activities. So again, so pleased to be here at MATS. Thanks so much for coming to our session. We're here to work with you. We're here to answer your questions. And with that, I'm going to turn it back to Jack, who's going to facilitate the rest of the conversation today. Thank you.
Thanks, Robin. So one of the things that I didn't say, and I should have, but I wanted to let Robin speak first, is I certainly appreciate all you do. Not just I, we all do at FMCSA. Hey, let's be realistic, folks. You're the one who's got us through the pandemic, and I'm not saying we're out of it right now, but you're the ones that were operating state to state, getting us through the pandemic, delivering those goods and services that we all need, that we all use every day. And for years, you know, some people do know me here. I've always said what I want to do is promote commerce, and that's what you do every day. And I want to promote commerce, and I want to do it safely. And I know you do, and I want you to go home to your families, your friends, your loved ones. So my gratitude, our gratitude for all you do every single day. This world can't survive without you, so thank you very much, and give yourselves a little applause there. I mean that. So, entry-level driver training kicked in beginning of February. Tom Liberatore is here to talk about that. And right now, Tom currently serves as our acting director of safety programs. He oversees the CDL division. He oversees the drug and alcohol division, our national training center. And basically, he's a jack of all trades, but today he's going to be the jack of all trades for entry-level driver training. Tom served with us about 7 years. Prior to that, he served 9 years as the Director of Driver Licensing and Education and Enforcement for the state of Maryland. So I welcome Tom Liberatore.
Thank you, Jack. Good morning, everyone. I appreciate you not adding the last half of that statement, which is master of none, because I think that may qualify in some instances as well. Very happy to be here today. It's my first time at MATS, I'll confess, but really excited to be able to talk about what we've been doing with the entry-level driver training program. As Jack pointed out, it is new. It just went into effect on February 7th, so hopefully the clicker will work. And it looks like it's not. So I may have to ask the guys in the back to advance the slides for me. There you go. You can keep going. Okay, so as you may or may not know, the entry-level driver training rule is actually published as part of MAP 21 back in 2016. So it's by no means something that was recently passed. And there's somewhat of a history with the entry-level driver training program. Many of you probably know we actually was originally supposed to be implemented in 2020, actually delayed implementation until 2022, which is the February 7th compliance date. We were also the subject of a lawsuit as to why we had not implemented it. So there were a couple things that were going on in terms of our voluntary delay of implementing the rule, then also the court requirement that we implement it. So in terms of dates, the February 7th date, once that was set, that was firm, and we did hold firm to it. We were able to successfully launch the TPR, which is the major component, the outward-facing component of the ELDT rule, on February 7th. And so far, everything is going well with our implementation. As I pointed out, the major component, there's really two. So there's the training requirements that we are having all new drivers having to complete, which is the entry-level driver training portion. And as a part of the rule was also creating the trainer provider registry, who are the private, public, and I'll cover this a little bit later, institutions that actually conduct the training prior to those interested in obtaining a CDL go into a driver's licensing, a DMV, MBA, and actually take the test. So who is covered under the ELDT rule? Summation, you can see it here on the slide. Pretty much anyone who is going to be getting their CDL for the first time. So if you've never held a Class A, never held a Class B, never held a hazardous materials or H endorsement, never held the passenger or the school bus endorsement, if you've never had any of those before, you are required to complete the entry-level driver training requirements. It does not cover individuals whom the state has exempted from taking their skills test. And that's an important distinction for two reasons. One, so our veteran drivers, our military veterans who participate in the Even Exchange program, the military skills test waiver, does not apply to them, obviously, because we're waiving the requirement for the skills test. So that makes sense. They wouldn't be required to complete the training because they, in essence, have already met the skill component of that. The other portion that's important to note is you need to complete ELDT prior to taking your skills examination. If you're getting a Class A, Class B, never held it before, getting the PRS endorsement. For the H endorsement, it's just a knowledge test. There's no skills test for that for the hazmat. So it will be just completing the ELDT training before you add that H endorsement to your license. I'm going to preempt possibly a question we may get because I get this frequently, that we've heard some states have been asking people, particularly those who are renewing CDLs with the H, that they have to complete ELDT. That is not true. If you do run into that, and I'll give you the email addresses a little bit later, let us know so we can reach out to those states and remind them. You know, states do have the freedom to be more restrictive, as they do with most things that we do, but in terms of our requirement, that is not the federal requirement that you have to do that. Again, so entry-level drivers must complete the applicable training from a registered training provider. As I said, must be completed prior to taking the skills test. If you obtain a commercial learner's permit on or after February 7th. So if you held your learner's permit prior to February 7th, you are not required to comply with the ELDT requirements. You can go in, continue on the path as it existed on February 6th, 2022, and continue taking your skills examinations and everything else you need to do. But if you get your CLP on or after February 7th, and if you held a CLP and let it expire, and now we're getting a new commercial learner's permit, you will be required to complete the ELDT component of the training, the necessary training and such. And that's actually the last bullet there. So I went ahead and covered that one. So what's actually covered? So if you look at what's in the ELDT as terms of the training requirements in the final rule, there's two components. You have theory training and the behind the wheel or the skills training. Those of us that took non-commercial driver's education when we were kids remember it's basically the same thing, right? You have the theory classroom portion, and then you sit with someone who's going to take you out and see if you can actually drive the car. In this case, you can drive the truck, depending upon what class you're getting, appropriately meet the skill requirements. So the knowledge, the theory portion, typical classroom instruction. Lectures, demonstration, it can be computer-based, it can be online. You don't have to necessarily be in the classroom, and you'll see, I'll talk about this a little bit later. They have a number of providers that do online training. So this can actually honestly be completed through a computer, depending upon what it is that you're trying to accomplish, or really to suit your own personal learning style. You can use a simulator. You can't use a simulator for the behind-the-wheel skills portion, but you can use a simulator as part of your knowledge training. This is also important because we do get this question a lot as well. There are no minimum number of hours in order to complete the training. If you look in the rule, we have a website that goes through all the requirements for the training provider registry and ELDT. It's all milestone-based. So when the creator, the instructor, be it theory or behind the wheel, feels you have mastered the necessary skills, that is completed, and you're done with that training, and they certify and upload that information. So it's not, some of you may be familiar, 30 hours, classroom, 6 behind the wheel, or whatever. There's no minimum hour requirement. It's all knowledge and performance-based. Some of the training topics include basic operation, safe operating procedures, how to deal with a malfunction. Of course, covers hours of service. I'm sure we're all familiar with that. Covers hours of service requirements in terms of the theory. The behind-the-wheel training covers actual operation of a commercial motor vehicle. It can be on course or on the road. You cannot, as I said, use a simulator to meet those requirements. And it really just covers basic vehicle control and mastery of basic maneuvering skills. We do get also a question sometimes as to who can be an instructor. So if you are wanting to be an instructor, the ELDT regulations, which are in 380.600, subparts F and G, goes over who can be an instructor. Basically, you need to have 2 years of experience. So you need to have a CDL, have to have 2 years of experience in operating the class of vehicle or that you're testing or training on, and the appropriate endorsements to do either knowledge or behind-the-wheel training. There is an exception that if you have an expired CDL and you used to hold, and you no longer hold the endorsement that you're training for, but it's just on the range, you can also still do the training if it's just on range. The exception can get a little bit particular, so if you have questions about that or think you want to be a training provider, you can obviously reach out to us and we can walk through what that is. So any entity that is listed on our training provider registry is eligible to receive training through. That could be training schools, educational institutions, motor carriers. Have a lot of motor carriers that are signed up on the training provider registry. Marked private, they only train their drivers. Totally allowable. If you, no matter what size carrier you are, if you have 3 trucks up to 3,000 power units, you can be a trainer and you can mark yourself as private and you can only train your individuals that you want to drive your trucks for your company. Owner-operators. So if you're an owner-operator, if you're a solo operator, if you have 1 or 2 people, or maybe you want to train someone else, maybe you're going to be passing the business down or passing your truck on to someone else, you can also register as a training provider. The rules for that and the process are listed on FMCSA's website. It's a self-certification process, and I'll go through that in a couple minutes. But really, it's a pretty wide berth of individuals that are allowed to be training providers under the rule. So what are the actual training requirements? So training providers wishing to provide ELDT have to register through our provider registry on our website, and you self-certify that you meet our requirements. And when you go on there, you'll see all of the requirements, as I said, are listed in 49 CFR Part 380, particularly Subpart G, lists everything that you need to meet. Also, if you go to our website, The Training Provider Registry website has special sections for drivers, for training providers, if you're a law enforcement personnel, or if you're a state driver's licensing agency. The FAQs that are on there, you can sort them and be tailored specific to you to walk you through it. Basically, when you self-certify, what you're certifying is that you have met the curriculum standards as they're outlined in Part 380. Identifying what type of facility you're going to have, if it's in person, what those are, online, what type of online system you're going to have, the instructors that you're going to have. Again, that's really getting to the instructor certification requirements. Make sure that you are abiding by any state licensing requirements. So if you are going to be opening a training provider school in the state, you want to make sure you're also following whatever your state may require. As Jack indicated, I used to do this in Maryland. I was actually in charge of driver education in Maryland. So as an example, you want to make sure that you're abiding by, if you're opening a driving school as your state defines it, that you're following whatever your state requirements are for that as well. Also, any vehicles, make sure obviously your vehicles are properly registered with the state in case there's special certifications or inspections they need to have before you enter into any training. All right, so what's the actual registry? So I've mentioned the website several times. This is what it looks like. This is at least the front page to it. It contains the official list of providers. It also allows you, if you are a training provider, to upload the information and then retains that information on who has completed training, so then the state driver's licensing agencies can go in and query to make sure, yeah, they're ready to go to the next step and can take their skills test. So how does a training provider registry support the actual rule? Well, pretty much it's just the actual steps that we've outlined already, or I've outlined in what I've said this morning. So as the training provider provides the necessary training, they then submit the certification completion to the TPR, which is then retained in that database. And then the state retrieves that information when you go in and take your skills test. So if you're going in, you're a new driver, you have your learner's permit, completed everything, going in to take your skills test, the state should be querying that system when you go in for that to make sure, yeah, okay, you're ready to go. We've gotten some questions on this too, particularly with the past few months with the trucking action plan that the president, the administration put out. Some states have been running into some questions on, do we have to wait to schedule the appointment until you complete? We actually have an FAQ on this on our website, so if you've run into this situation, we don't require the states to wait to schedule a test until you've passed completion. Our stance is, and our rule only requires that before you're actually administered the test, you have to check with the registry to make sure the student has completed training. So state can schedule a test before you've completed, but obviously if you show up for the test and you haven't completed it, they're going to make you reschedule your appointment. In terms of overall training providers, so there's two lists that we're working with here. We've got the total number of training providers, which since we started actually taking registrations back last June, we've got over 10,000 actual training providers across the country. It may be hard, you may be able to see it on that screen. The numbers are kind of tiny, I apologize for that, but I think the presentation is going to be uploaded, and if you have a specific question about a training provider, the number of providers in your state, the great thing about the training provider registry that's on our website is you can go in, put in your state, what type of training you're looking for. If you want to be online, if you want to be in person, you can search and it'll provide you back that listing of all the training providers that are meeting your criteria. So it is a searchable database. You can also print, download the information if you want to call them. Many of them also have websites you can search if you want to go that way too. Now in terms of actual locations, we have over 14,000 approaching 15,000 locations. And I've gotten this question a couple times is, well, how can you have more locations than training providers? It's because a training provider can have more than one location. Actually, a colleague asked me this last night, and that's not the only person. They do get that routinely. Particularly if you're talking about online, they can be in multiple states. You do have some providers that are across the country. Some of these larger institutions, particularly if it's a large carrier, they'll register as a provider, and then they'll drop locations in 5 or 10 states. but you can absolutely have multiple locations yourself if you're interested in doing that. So where can you get additional details about the rule? I have the website up here. If you forget, don't write it down. I will confess, go to your favorite search engine. I'm not going to plug any particular internet search provider's product today. If you go into your favorite search engine and type FMCSA, TPR, or FMCSA, ELDT, pretty much guarantee you the first response back you're going to get is a link to this website. So if you forget this today, you can go and use any search engine. It'll pick it back up. We've also got an email. You can obviously contact us. You can also contact your local division office of FMCSA if you have any questions. They're all updated. We have routine discussions on it. We've also got an email address that I can never remember, but I did write it down. It is, I should remember this, tpr@dot.gov. So you can also email us. We have been very responsive to emails, particularly if it's from drivers and carriers that are needing to train and get their prospective drivers through the process. So I believe that is my last slide for this today. So before I turn it over to Jack, to turn it over to Brian, or just hand it to Brian, does anyone have any questions? Yes, sir.
Does that, someone coming in from out of country, whether it's a B1, coming from Mexico, or something that's Canadian license or Europe, they were able to just take the test before.
Mhm.
Now they have to take a step back and go through the whole program.
So that is a great question. There are certain circumstances where if you are coming in, just for those of you that couldn't hear, the question was essentially if you're a non-domicile CDL holder coming in from a foreign country, do you have to go through the process? In many cases you don't. We're actually dealing with some issues right now with a number of asylees from foreign countries that are trying to get in, actually held CDLs from other countries beside Canada and Mexico. So it's a dual process of making sure they meet the non-domicile requirements to get the CDL issued, and then do they have sufficient documentation for us to prove that they actually met the experiential requirements for the rule. That's probably on a case-by-case basis, to be honest with you. If you run into a specific scenario, obviously reach out to us and we'll try to give you the answer specific to that situation. Yeah, that is exactly some of the challenges that we're running into right now, especially you can guess what countries we're talking about in the past year where people are coming in and they have trucking experience and they want to get into the industry, and it's an issue of getting the documentation to prove the domicile issue and then getting into, okay, now are they going to have to take ELDT? Probably in many circumstances they might have to complete that process if we really can't document they've got that proof, but there may be some exceptions to that. And I can't see because I'm getting blinded by the light, but yeah, you can just yell too.
Talking about the providers having numerous locations.
Mm-hmm.
So if I've done the registry and I'm going to have several locations, it's going to be a business for me, do all of my trainers have to go through the registry?
So you would.
Because I'm going to be hiring people if I have more than one location.
Right. You would register as a provider.
Mm-hmm.
And then when you would also list for us your locations. You can also go in and update your registry information. Your instructors, you could just add that information to your certification requirements. In many instances, if you're hiring someone, we do have the authority in the rule to do routine audits of carriers, but at that point, that would be your business documentation to maintain as part of your business and to make sure that your instructors, one, meet our minimum requirements, which I'm glad you asked this question. I meant to emphasize this and did not. What we establish, obviously, are the minimum requirements for the TPR. Your state may have additional ones that you may need to meet. But that would be the instance where you would just need to maintain the proper information for your business, make sure your instructors meet our, and if there are any additional state requirements, and then just update your registry information as you need. There's back there, Martha. Red lady in a red shirt. I can see that, even with the light.
Good morning. I have a question. When In the rule, it says that you could go in and audit these these ELDTs. Once you go in there and you audit the process and you find out they're also a motor carrier, where's the crossover if you find out that they have some denotes? So not too long ago, I went and helped a motor carrier become ELDT in the profession that I do. And in the process, I also found out this motor carrier had 3 denotes. So what is FMCSA's process when they're going to go in to audit these and find that these motor carriers are in that category?
Okay, so that's a great question. That would depend probably on what the specific issues that carrier is having are. We do encourage, obviously the states also have the ability to go in as part of their requirements to audit a trainer whenever they feel necessary. If you are aware or there's a concern about a provider, we do ask people to email us or contact us directly through the tpri.dot.gov. They can also contact their division office. It really depends upon what their specific issues are. That's kind of somewhat of a difficult question to answer because they really are separate activities. From our perspective, you have their motor carrier operation, and then they're also saying, I'm a training provider. That was probably something we would need to see specifically what the issue is. Yeah.
So the carrier themselves was a private, so they're not even required to do the ELDT, but they are for themselves. And when I went to help them get set up, I found out they had the 3 denotes in areas like hours of service, travel fitness, and I don't remember the third one, but I remember there was 3. And I told them that from a legality standpoint, what their issues were, but from an FMCSA to come in to audit, there's a probability that they should come back and audit
Yeah.
for DOT number because they're both hand in hand. But is there a process in the bill or in the Fed Register that will allow you to automatically do that? If you find out they do have one a ELDT and then they're also motor carriers, is there something that's going to tie that in together to become an automatic process?
So, there's nothing that gets into that level of specificity, at least that I can recall in the rule, other than just our blanket authority that we have the authority at any point to go in and audit someone's records. So if someone is a motor carrier and they've self-certified and they've registered and through our evaluation process, we're aware that, hey, they may have some basics that are above the national average and we're going to be concerned about that. As of right now even, yes, we've absolutely got the authority to go in and say, hey, okay, there's a problem. And if through that investigatory process we find out, yeah, you know what, they should be out of service, or we're going to make sure they're marked as an out of service carrier or unsat, unfit, then we can also at that point say you also can't train. Because obviously that would be kind of counterintuitive at that point.
You also said they would even report it in the email. So I have a full obligation now because I go in and help them get ELDT certified, and then I have to turn around and turn them in because you have to do that.
No, I'm not saying you have to personally turn them in, and be a, yeah. Right. No, that general statement is if members of the public, are aware of someone or an issue that requires, or like, hey, this person's certifying training and they really aren't conducting the training. Or they say they have a classroom and you go there and it's 55 degrees and it's got one broken TV monitor. Those are the types of things that we can also make sure that if you do run into that we want that feedback or input on. Obviously, if you're a company that engages in this, from your own personal stance, whatever your liability might be, you're free, obviously, to do that. But when we do get that information, we do conduct an investigation, and we do have the authority to take action against that person through the registry.
That's okay, sorry. I'm Ingrid Brown. I'm one of your FMCSA Voice of Safeties. And I have a question about this. No, I'm not asking about me being a trainer or anything. I'm asking about, I know this is a baseline for the starting of the training implementation. Is there going to be changes or possible changes as we see maybe hours needed to be added to this for more training? It's kind of like a doctor. or a law enforcement officer, they have to meet so many hours or so many years or so much time frame. And 42 years in this industry, it's hard to do that without any hours and doing seasonal, doing winter driving, doing this type of thing. Is this going to be able to be relooked at? Is this going to be
Yes.
able to be changed? How are we going to look at that?
So obviously it's new, right? We're about 6 weeks into it. We will be evaluating the effectiveness of this. It's going to take us some time to get some data on it to see what that might be. So as with any rule that we implement, there's always the desire to study its effectiveness and see if any modifications need to be made. If that does happen, that'll go through the typical process where we would, upon notice of proposed rulemaking, get comments. So yeah, all that is on the table long term. I think that's the last question. I'm getting the go to Brian notice. So thank you. Thanks, Jack.
So thanks, Tom. Give Tom a hand. So you may have other questions. I'd be remiss if I didn't acknowledge the people that are here from FMCSA. We have a booth, and I hope you stop out and see the booth. So we'll just, everybody from FMCSA stand here. We've got a team from headquarters and the field. And we're all going to be at the booth of the day. Stop by and, ask specific questions. You may have one-on-one time with people just to get some other, topics discussed. So thank you very much, Tom. So next I want to turn it over to Brian Price. Brian currently serves as the division chief for our drug and alcohol program. And over his 32-year career with FMCSA, he's served various positions. He was a safety investigator in the field, a transportation specialist, served as our border chief and so forth, and now he's the drug and alcohol chief as well. So I'd like to introduce Brian Price.
Good morning, and thanks, Jack. Before I get started, I want to ask a question, and I think I know I'm going to see a lot of hands, but I'm going to ask anyway. How many people in this room have had some interaction with the Drug and Alcohol Clearinghouse, either registering, entering violations? Okay, so it's a large number. All right. So let's go ahead and get started here by flipping on to the next slide. Okay, what I'm going to cover, I'm going to give just a very high-level overview of what the clearinghouse is, give you a little bit of background on it, and kind of a heads up on some additions that are coming. Talk a little bit about the various user roles, whether you're a driver, what you do in the system versus if you're a motor carrier that employs drivers. And then I think what a lot of folks are really going to be interested in is some of the statistics we've gathered so far in the 2 years that the clearinghouse has been operational. And then I'll show you some web links and some resources that are available to you to follow up on additional questions you might have. So if we can go ahead and move on to the next slide, please. Okay, so what is the clearinghouse? Okay, I would say in its purest sense, basically, it's a database where CDL drivers' drug testing violations are reported to us at FMCSA. And when I say violations, I'm talking about positive test results or a refusal to test. Or another example might be getting cited for DUI in your truck on the side of the road. Those type of violations are now reported to this database that we maintain at FMCSA. The information in this database isn't available to the general public. A lot of you guys raised your hands. My guess is you raised your hands because you've interacted with the system to provide consent for an employer to check that database. And that's another big feature of this clearinghouse, kind of the regulatory requirement is these violations are reported to the clearinghouse because now as part of the hiring process, motor carriers check this to make sure that a driver doesn't have a violation, isn't prohibited from operating a CMV before they put the driver on the road. They do that at pre-employment, and then there's also a requirement that they check every driver on their roster at least once a year to make sure they maybe haven't snuck off to apply it somewhere else and tested positive that they don't know about. Okay, so let's move on to the next slide. Okay, just a little bit of background. First of all, this clearinghouse isn't something that we at FMCSA or DOT just dreamed up. This is something that Congress mandated back in MAP 21 several years back. And there was a lot of industry support to establish this clearinghouse. And I think one of the drivers of this, no pun intended, was that a lot of companies, they would do a drug test on a guy. They'd test Joe, he'd test positive for something, and say, I can't hire you, sorry. And then they'd look a few weeks later and they'd be like, well, what the heck, this Joe guy that tested positive, I know he's working for my competitor over here. Why is this happening? And we all know what was happening. Joe would wait a couple weeks till he could give a clean specimen, then he'd go over somewhere else, test, he'd be on the road. Well, this clearinghouse is designed to prevent that from happening, all right? So that's just a little background on a little bit of the impetus behind it and why it was established and why Congress thought it was important to mandate it. Now there's a second rule. I said this is kind of a heads up on what's coming. The rule's already been published, but what this new rule is going to do, and it's not effective until November of 2024, but it's going to make these consequences associated with a positive test or a refusal actually linked to the commercial driver's license. In other words, through this, what we call the Clearinghouse 2 rule, we're going to establish a connection between this database we have at FMCSA and all the state driver's license administrators, so that if you get a positive drug test, that's going to be fed down to the state driver's license administrator, and there's going to be a downgrade of the commercial driver's license privilege. So that's just a complex way of saying there's now, in the future, effective November of 2024, there's going to be an impact to the license itself, not just a record in FMCSA's database. Okay, if we can go on to the next slide, please. Okay, I'm going to run through this somewhat quickly, these various user roles, because I think what most folks are probably interested in is what kind of numbers and statistics we're seeing. So if we can go on to the next slide here. Employers, obviously I said what employers' big obligation is to do their queries, right? When they hire a driver, do that pre-employment query to make sure Joe doesn't have a positive test from another company, for example. And also their annual queries of everyone on the roster. Okay, we move on to the next slide, please. As drivers, a lot of you guys are drivers. I saw a lot of hands raised. One of the driver's requirements for this system is to provide consent to these query requests. To provide that consent, especially on pre-employment, drivers have to register in the clearinghouse. And by the way, we know that a lot of times there's technical issues with trying to register, get your license to validate. If you want to talk to us about those kinds of things, Jack reminded, we've got the booth set up. We'll be in the back of the room afterwards for those kind of questions and also at the booth all day. Okay, if we can move on to the next slide, please. Medical review officers, substance abuse professionals, they're part of the drug testing process. They both have to register in the clearinghouse and report violations. One common thing I always mention is, one of the employer requirements is not to report positive tests. The medical review officers report positive tests to the clearinghouse. Employers report refusals to the clearinghouse and return to duty results and that kind of thing. And I always point that out because sometimes we'll see a driver get duplicate positives reported to the clearinghouse. The MRO does what they're supposed to and reports it, and then the company thinks, oh, I've got a positive, I got to report this too. Again, that's the medical review officer's responsibility to report the positives. Then, of course, substance abuse professionals are part of this process for drivers that might test positive. Okay, next slide. Or have a refusal. Okay, statistics. Again, I think this is what a lot of folks are probably interested in, what kind of numbers we're seeing in the 2 years that this database has been fully operational, the clearinghouse. So if we go on to the next slide. I don't know that folks can really see these numbers, so I'm going to do my best to explain them. This first one is just a measure of how many unique CDL holders have actually been checked in the clearinghouse. And you can see here, or maybe you can't see, I'm going to tell you if you can't, but since the inception of the clearinghouse, we've had over 4 million unique CDLs queried. It's a big number. I don't know exactly how many CDL holders there are in the U.S. I think our rough last numbers I looked at ballparked it at around 5 million. So this is telling us that employers are doing what they're supposed to do by and large. We know there's some that aren't, but again, over 4 million CDL holders have had their records checked as part of the pre-employment or annual query process to make sure they don't have a violation in this clearinghouse. Okay, move on to the next slide. Now, I know you can't see these numbers. These are available on monthly reports on our clearinghouse website. But a couple things I wanted to point out here. We see in 2020, there were roughly 44,000 positive tests. 2021, that number inches up over 48,000. So a little bit of an increase in the number of positive tests between 20 and 21. Now what we don't have, and this is an important thing, we don't have reported to the clearinghouse how many tests that have actually been done. So we know that the number of positives have gone up, but we don't necessarily know that the rate, the positive rate has gone up. In other words, we don't know that the percentage of drivers testing positive is any higher than it was before. Another thing I'll point out from these is refusals. And this is something that surprised me coming into the drug and alcohol testing program. But between 20 and 21, over 15,000 drivers have had a violation reported for a refusal. Okay? So, and a lot of these refusals are, we know, or we can guess anyway, you know, the guy gets selected for a random, he's advised, hey, you need to report down here to Quest for a random test. He knows he's going to test positive, so he says, I'm out of here. You know, that's a fair number of the refusals, of course. But I think I always caution folks, especially in the driver community, because the consequences of these refusals are the exact same as if you tested positive, okay? And I think sometimes, you know, we look at a lot of petitions or appeals of these, and we'll hear from guys that say, well, yeah, they called me on the 20th and told me I needed to go in for a random, but I already had a start date set up over here at another company, so I just blew it off. Don't do that, okay? You do that, the company that told you you needed to report for the positive is going to report that violation. Same consequences as a positive result, okay? Another one we see a lot, guy goes to the testing facility, temperature out of range on it, and you know they're told you gotta stay here. You got 3 hours to provide another specimen. They'll say, well, I got to go pick my kid up at school. I'll come back tomorrow. No, same thing. It's a refusal. So those are just a couple, because we see so many of these, like I said, 15,000 in the last couple of years, just something I always try to stress to folks. Okay, if we can go on to the next slide. Okay, what are people testing positive for? This probably isn't a surprise to you. We've had, out of 115,000 positive drug test results reported to the clearinghouse over the last 2 years, over half of them, I think the number is around 55%, so here's 64,000. Again, this is not a surprise, marijuana, okay? Marijuana, even though it's been legalized in some places, it's still a prohibited substance. Can't smoke marijuana and drive a truck, you know. Like Jack mentioned, I used to do border work. Canada legalized cannabis across the country. So I used to go up there and they would always ask, well, since it's legal up here, can you drive in the U.S.? And the answer is No. You know, I used to always give the example, it's kind of like, you know, Colorado was one of the first states to legalize marijuana. I used to always give the example, if a guy plays for the Denver Broncos, he still can't smoke weed and play in the NFL. It's a prohibited substance. Same thing. Another thing I always, it kind of struck me about this data, like I said, marijuana is a little over 50% of the positives. But if you take a close look at it, you can see here cocaine, meth, amphetamine. You add those numbers up, about 1 in 3 of the positive results or positive tests that are reported to the clearinghouse have either cocaine, methamphetamine, or amphetamine reported. So again, these are the kinds of things that I think we can all agree. We don't want drivers out on the road that are engaging in these kinds of substances. Okay, next slide, please. Okay, another statistic that people are interested in is, okay, we understand how this clearinghouse is supposed to work. A positive result or refusal is sent in, that driver is prohibited from operating. Well, how many drivers has this actually affected? Well, over 108,000 drivers have had a violation reported to the clearinghouse and have gone into prohibited status. I mean, you're not allowed to drive a truck anymore. The number that currently sit at prohibited status, I think this is as of the end of December, a little over 83,000 drivers are currently prohibited from operating until they complete a return to duty test or return to duty process that I'm going to talk a little bit about. Another number you might notice up here, out of the 83,000 that are currently in prohibited status, over 62,000 haven't started that return to duty process to get back on the road. Okay, so that's roughly 3 out of 4 haven't started that process. They're still in prohibited status. Okay, and go on to the next slide. Okay, again, I apologize. I know you can't read this small print from anywhere beyond the front row, if you can even read it there. But I did think it's important to talk a little bit about what this return to duty process entails. Okay, if a driver does test positive or has a refusal reported to the clearinghouse, that's not the end of the road, so to speak. There is the potential to get back in good standing, but there's a process, okay, that involves a substance abuse professional and follow-up tests and that kind of thing. But the first step in that process is the motor carrier that the driver is tested for is supposed to provide a list of substance abuse professionals that it can be referred to. Then the driver designates in the clearinghouse, I'm going to use this substance abuse professional office here in Lexington, Kentucky to evaluate me. The SAP does an assessment. You know, they talk to you, they look at your history, and they make an assessment on what kind of treatment you need. Do you need just some online classes, or do you have a real bad problem where you need in-house treatment? Anyway, this substance abuse professional makes that assessment, establishes a program that you got to go through, and then that substance abuse professional will determine whether you're eligible for what's called a return to duty test. Okay? And they also establish a follow-up plan. Now, by our regulations, that follow-up plan requires at least 6 tests over a 12-month period that are observed tests. A little bit more complicated. These return to duty tests have to be observed. Okay? But then once a driver passes that first return to duty test, you know, they've been cleared by the substance abuse professional as eligible for a return to duty test. They go in and have an observed test. That first one, it's clean. Then that prohibited status comes off their clearinghouse record. They're back on the road, and the motor carrier just has to make sure that they follow and abide by the follow-up plan. You know, it might be 5 additional tests over the next 12 months that are unannounced or whatever it might be, until they finish it, and then the follow-up testing plan is marked as completed. So, Okay, going to the next slide. Okay, I know there's going to probably be a lot of questions. We have a great website, and I say great, I'm not patting myself on the back because I wasn't involved in setting it up, but I've looked at it enough to know it's a very informative website. Our clearinghouse website has a ton of tools for various roles, like you have questions about how to register. There's driver-specific tools. There's motor carrier-specific tools, MROs, little job aids and things like that. There's even videos on how to interact with the clearinghouse, how it works. I'd encourage everyone to go to this Learn section of the clearinghouse, or also email our specific clearinghouse@dot.gov email address if you have specific questions. But again, I think now is an opportunity. Yeah, we've still got a few minutes here if anybody has questions. Yes, yes, ma'am, the red back there.
The question I have is that I had a particular situation where a driver tested positive, had been not employed for over a year, year and a half. The carrier said, well, he said that he went through the SAP program, so I'm just going to go ahead into the Drug and Alcohol Clearinghouse and say that he has completed the SAP program. Goes in, puts the information in there. The problem with this, where's the support of the documentation that prohibits this from happening?
Yeah, that shouldn't happen.
It does.
The motor carrier shouldn't be allowed to enter in that the driver has completed the SAP process unless they're somehow registered as a substance abuse professional themselves.
But the SAP refused to do it,
So you're saying
according to this motor carrier.
Right.
The motor carrier refused to enter this information.
Or the SAP did.
Yes.
The SAP.
And so the motor carrier says, well, I have the documentation now, so I'm going to go in here and complete this process.
Oh, okay, you're saying the SAP provided documentation, but the SAP itself didn't enter in.
Initially, the motor carrier didn't have it.
Okay.
The motor carrier finally obtained the document from the SAP,
And they entered it.
and the motor carrier went ahead and entered it. But the problem is that where's the supporting documentation that prohibits a motor carrier from going in and entering this information without the supporting documentation?
Yeah,
Hi, everybody. I'm Gian Marshall. I'm the Drug and Alcohol Clearinghouse Program Manager. And to respond to your question, ma'am, the motor carrier does not have the functionality to actually report all of the return to duty process information. The beginning of the process in the clearinghouse for a driver in their return to duty process is to designate the substance abuse professional in the clearinghouse. Once the substance abuse professional actually accepts the designation, then they can go ahead and enter in the date of the initial assessment and the date that they determine the driver eligible for return to duty testing. If what happens is that that information is omitted and the SAP does not actually enter the information, even if the carrier enters in the negative return to duty test, it will not get associated to the driver. The driver will remain in a prohibited status. If for some reason the carrier or somebody else says, well, I completed the driver completed the return to duty process, they saw a SAP, what they need to do is reach out to us and the clearinghouse team, clearinghouse@dot.gov, provide the documentation, we will look into the situation, and then we will go ahead and reach out to the applicable individuals to make sure that all the information is reported appropriately. So we don't actually require a document upload. That part of the reason why is that it does cause an increased burden to certain users. So in the case of a substance abuse professional, they wouldn't be uploading any of the documentation that relates to the return to D process, especially the follow-up testing plan. Any information that is recorded in the clearinghouse on a driver must be allowed access to that driver. So of course we don't want the drivers to know what their follow-up testing plan is, because it is supposed to be surprise tests. And so if they have access to that information, they could prepare to go ahead and take a follow-up drug test. And that's not the purpose of a follow-up testing plan.
All right, one more question and then we need to wrap it up, but thank you.
One thing that I think should be addressed is a segment of the industry where drivers work as independent contractors, like drive-away and temp services. If you sign up with 3, 4, 5, or even more, which is not unusual, like drive-away companies or temporary agencies, each one of those, you have to take a drug screen and you have to be subject to random drug testing by each one of those companies that, as a motor carrier. There should be a provision for an independent driver or somebody who's doing work for multiple companies to join a consortium, and where the motor carrier can be relieved of that as long as there's documentation to show that you're in compliance with the federal standard.
Thank you, sir.
Yeah, and there are, I mean, as an owner-operator, you're required to join a consortium, but if you're not an owner-operator, you're bounced around working for different motor carriers, there are exceptions in the regs for pre-employment testing, which is, and it's essentially, if you're in a random pool for another carrier, and they can verify that with the other employers, and you don't have to be in additional pools or even be pre-employment tested necessarily. But a lot of companies, they find it's just easier to say, go take the test and I'm throwing you in my pool, rather than trying to contact the other carriers and those kinds of things.
So thanks, everybody. I want to give the panel here a hand.